Ramesh, Kanna. I'll repeat myself. I'll first begin with the order of proceedings. Good evening, members of the tribunal. My name is A. Ramesh Kanna, and I act for the applicant, Mr. Antonio Fortuna, with my co-counsel, Mr. Brandon Zhang. I will talk about the first two issues for 10 minutes, and my co-counsel will talk about the last two issues for 10 minutes, and we respectfully reserve 1 minute for rebuttals. Now, members of the tribunal, CAS panels have to make a decision between procedural justice and substantive fairness. And we understand that on this sliding scale between substantive fairness and procedural justice, in the vast majority of cases, the position to be taken has already been set in stone under the CAS code. However, in exceptional circumstances, this particular position can be changed by the panel. And that is what the applicant argues today. With this understanding, I make two submissions. Firstly, the statement of appeal is admissible. And secondly, Mr. Fortuna's refusal to hand over his phone was not unlawful. Now, with regard to my first submission, I make it on two grounds. Firstly, the statement of appeal was attempted to be filed within the deadline. And secondly, it was late because of exceptional circumstances that would warrant reinstatement. Now, we do not contend the fact that the statement of appeal was indeed sent in late. This is because by virtue of R31 of the CAS code, electronic documents are only considered to have been sent when they have been received within the sphere of control of the recipient. And in the present case, due to the cyber attack, the email had not left the applicant's server. However, the applicant had indeed attempted to send this within the deadline. Now, this particular issue matters because the opposing counsel may counter by saying that the statement of appeal was not even attempted to be sent within the deadline. And this is because there were two decisions that were provided. The first decision was provided on the 31st of March. However, the decision with full grounds was only provided on the 2nd of April. And the 21-day time period within which the statement of appeal has to be submitted only begins after the decision with the full grounds has been made, which was on the 2nd of April. Thus, when this particular filing was attempted, it falls squarely within the 21-day period. And the authority that I rely on is the 2013 CAS case of Dominic and Jatko, which states that only the decision of the full grounds would cause the 21-day time period to start rolling. Now, moving on to the second ground of my submission, why this falls within an exceptional circumstance that would allow for reinstatement is because the particular event or occurrence that caused the non-submission of the electronic file was not within the control of the applicant. Now, with regard to this, I refer to paragraph 30 of the record. If members of the tribunal are with me.
Yep.
So Mr. Fortuna's legal team immediately informed CAS, providing a screenshot confirming that their email servers had recently been subjected to a cyber attack, which had disrupted outgoing emails without necessarily generating delivery error messages. Now, the right to reinstatement requires the impediment to be unforeseeable. This is the underlying principle behind the no-fault threshold requirement. And this was
I just have a question, counsel, because when I look at the paragraph 30, it says which may have disrupted outgoing emails, but you skip the word may. Can I check if we know for sure that the cyber attack indeed caused the email to not be sent out, or is that important to your case?
I understand that there are two questions, Mr. Arbitrator, and I'll answer them in two parts. Firstly, with regard to the may have, the word may have shows that there has been a likely effect of it not being sent. Thus, we could not confirm it to 100%. However, when it comes to CAS jurisprudence, the standard of proof is that of comfortable satisfaction. And we would argue that this particular evidence meets that standard.
Okay.
Now, the underlying principle is that it must not have been a foreseeable error. Now, if we look at the 2023 SFT case of B and FIFA, the court rejected reinstatement sought due to a lawyer's illness. And the principle that the court used was that the lawyer ought to have foreseen that he was falling sick and should have delegated his particular job to someone else to file the statement of appeal in time. Now, although this is not an electronic filing case, the principle still remains something that we can apply to the current case. And if we look at the current case, the email was not sent not due to some technical error, but rather due to a third-party obstruction, a cyber attack, which the applicant had no awareness of and could not have protected against beyond whatever firewalls and protections that they had already installed. That is to be expected of any normal law firm. Thus, we would argue that the no-fault threshold requirement has been met here, and thus reinstatement should be allowed. And in this regard, the strongest argument that opposing counsel could make is to rely on the case of Iowa, which states that technical errors that disrupt electronic filings would not constitute the requisite threshold for this panel to agree to reinstatement. However, I wish to make the contrast clear that this was not a technical error on the server's fault, but rather a third-party obstruction due to a cyber attack, which was unforeseeable. Now, if members of the tribunal have no further questions, I would
Sorry,
like...
can you really say that cyber attacks are unforeseeable? And isn't it the technical error of the service provider that they aren't able to mitigate this sort of cyber attack? And is there anything to say that this is not part of a routine like cyber attacks or protrusion attempts into a particular team's network for it to be classified as something that is a very exceptional circumstance? So that's the first question. The second question is, within Swiss jurisprudence, is there anything to suggest that this is the practice with regards to Swiss tribunal cases or other courts?
Could I clarify regarding the second question, Mr. Arbitrator? When you say this is
Yes.
the practice, what is the practice that you're referring to?
So are there any other sports arbitration courts or Swiss courts that adopt a similar practice in these cases?
Okay, understand. So with regard to the first question, we would argue that a failure to protect against the cyber attack would not be a technical issue, but rather just the fact that the cyber attack was of a magnitude and severity that is beyond whatever protective measures that the law firm has adopted. And to say that if a law firm adopts practices that cannot protect against cyber attacks, they would be disadvantaged in hearings, would go against substantive and procedural justice for all applicants. Thus, we would argue that so long as the firm has adopted measures to protect against such intrusions, they have done their due diligence, and whatever attacks that breach these protections could not have been predicted with foresight. And with regard to the second question, yes, this is indeed the principle. The underlying principle is foresight, and whether they had foresight to mitigate the issue. And this has been stated in the 2023 SFT case of B and FIFA. Now, if there are no further questions, I will move on to the second issue with regard to whether or not it was unlawful for Mr. Antonio Fortuna to have not handed over his phone. Now, we argue that it was not lawful, and we argue this based on Article 6 of the ECHR, which grants the applicant a right against self-incrimination. Now, the protection against self-incrimination is a core procedural safeguard under the ECHR, which is invoked in cases where there are concurrent criminal proceedings with CAS. Now, this was noted in verbatim in the 2017 CAS case of Jerome Valquet and FIFA, where the courts found that there was no real and imminent danger that could prejudice Mr. Valquet's right to self-incrimination. So the threshold for this right against self-incrimination to be active is that there must be a real and imminent danger. Now, in our case, there's clearly a concurrent investigation that is taking place concurrently with today's proceedings. Now, if I may turn the panel's attention to Exhibit 5. which is the press release by the Iridonian public authorities. Are members of the tribunal with me?
Yep.
Yes.
It clearly mentions that Mr. Fortuna's conduct was under investigation, and at para 24 of the record, it further shows that a criminal investigation against Mr. Fortuna is pending. Now, I note that my time has elapsed. With regard to this submission, could I request for 1 minute to sum up my submissions? Yes. So, the determining factor for whether Article 6's right is invoked is if there is a real and imminent danger of whatever evidence that is collected in one proceeding to be collaboratively sent to the criminal proceeding. And in our particular case, paragraph 15 shows that FIFA proactively inquired with the public prosecutor about sharing evidence that they have found. And in paragraph 12 of the record, it's clear that FIFA has already sent evidence that it has obtained to FIFA. Now, this sort of collaboration shows that there's a real and imminent danger that if the appellant had indeed sent his phone, whatever the contents of his phone were, would also be sent to the public prosecutor, infringing his rights against self-incrimination, which is a breach of a procedural safeguard that exists for the appellant. Thus, it was lawful for him to refuse the handing over of his phone. With that, I conclude my submissions if I may be of no further assistance. Thank you.
Mr. President and Mr. Arbitrator, my name is Brandon Zhang, as introduced earlier, and I appear for the appellant. I will speak on two issues. First, on issue C, I will show that the respondent's case relies on anonymous evidence, which under settled caste jurisprudence cannot establish individual player involvement and therefore carry no evidential weight. On issue D, we submit that the suspicious betting patterns does not permit an inference of guilt, and I will demonstrate that CAS has expressly rejected inference as a substitute for proof, and this requires a direct link. I now turn to the first submission. The anonymous evidence is inadmissible for three reasons. There are strict conditions that has to be met. Second, these conditions have not been met. And lastly, even if admitted, they carry no evidential weight and does not meet the threshold. The starting point can be found in the 2011 CAS decision of UCI versus Alberto, where the panel referred to European Court of Human Rights jurisprudence and the Swiss Federal Tribunal, which adopted measures to ensure the right to be heard and a fair trial to the party opposing the witness anonymity. The panel held that the use of protected witnesses is subject to the following conditions: necessity, a risk of concrete retaliation, and verification of ID and cross-examination. Now, the respondent relies on the 2019 CAS decision of Karamuddin versus FIFA, but it will conveniently leave out the fact that in that case, the panel did give the party opposing the witnesses the chance to verify and the chance to cross-examine the witnesses in a protected space. In that case, at paragraph 133 to 135, there were 4 protected witnesses who were female players of the Afghan Football Federation who were victims of rape, assault, and sexual harassment. And at one instant, the appellant had pointed a gun at one of the witnesses' face and threatened to kill her family. In the present case, we see that there is no direct threats, there have been no assaults, and moreover, in Exhibit 2 of the witness statement, the witness states that these are rumors that he heard that the father is involved with a criminal organization. And therefore, we submit that the evidence is insufficient to prove, and simply it cannot be that these rumors are taken to be true. And the respondent will argue that internal consistency is a key testing mechanism when the panel cannot verify.
Sorry. Just to be clear, in the current case that you cited at paragraph 130, doesn't the court acknowledge the propensity for potential threats to be a factor that the court considers and whether granting the witness anonymity is justified?
Yes, the court, those witnesses were granted asylum in exchange for testimony in that particular case. And the panel further provided a counsel to appear at the cross-examination to verify the identities of those witnesses. And lastly, with respect to Exhibit 3, we submit that the evidence is not admissible as it has not been verified of its authenticity. In Karamudan, at paragraph 188, the panel held that screenshot messages carries no evidential weight, even if there is a name attached to it, because the appellant have failed to prove its authenticity. In the present case, at Exhibit 3, this is an anonymous email with the name, the syndicate. Sorry, this is Exhibit 4 with the name, the syndicate, and email Exhibit 3 is also anonymous. And therefore, we submit that without the verification of the panel, it is inadmissible. If there are no further questions, I will proceed to the second submission. The respondent alleges my client of match fixing under Article 20 of the FDC. However, we submit that my client is not guilty for 3 reasons. The evidence has not met the threshold of comfortable satisfaction. The Genius report does not itself constitute match fixing, and the evidence does not provide the evidentiary link required to prove guilt. The 2-stage test is laid out in the 2017 CAS decision of Oleg Pinkovsky versus LFF at paragraph 83. I quote, "The fact that a match is considered manipulated is only the first step. The betting fraud detection system is by itself, without further evidence, insufficient to establish a link between appellant and manipulation." If I may now direct the panel's attention to page 15 of the PDF record. Here, this at the goals section, where the minute 6404 at the last line, beginning of the last word of the second line, no individual errors were identified in this passage. At minute 88:13, at the third line, Santiago pulled up with an apparent hamstring injury. And at the last line, not a performance error. The inability of Santiago to continue his recovering run led to the goal being scored. On 2 of the goals that were scored, these 2 goals have not been attributed or linked to my client, as performance injuries were involved by Santiago, and also there was no errors involved. On the next page, if I may direct the panel's attention to the next page, at minute 11, Royce miscontrolled a routine short pass in the middle of the pitch, allowing Iridonia to start a dangerous attack. At minute 61:54, second line, Reyes made a run to meet the cross at the near post. Despite having a clear path to tap the ball toward a goal, the forward awkwardly attempted to backheel the ball, misjudging the contact, and the ball ended up rolling out of play for an Iridonia goal kick. At minute 82, down below, the left-sided central defender Paul attempted a diagonal ball back towards his own goal under minimal pressure. And at the very last line, it says, though the effort was well saved by the Iridonia goalkeeper Fortuna. And here on the facts, we have suspicious play performance from 3 of the players here, and it was my client who saved the very last goal. And it has been held by CAS jurisprudence that first, even if there was match manipulation, the second stage is to prove that there was a link that existed. And the respondent's claim cannot prove that this link exists. And on these facts from the performance play, it can be suggested that there were multiple players that may have been attempting to manipulate the game. The respondent relies on the betting reports to suggest there has been manipulation. And members of the panel, we don't disagree. The facts and the reports from the betting report strongly indicates match manipulation. However, we submit that my client has not been involved for 3 reasons. First, the day before the match, he consulted the team's doctor because he was sick, yet he still chose to play. Now, secondly, the respondent will argue that my client, Mr. Antonio Fortuna, is a well-capable player who had recently built a reputation as a solid player. However, we submit that my client was the backup goalkeeper reflected at page 2, paragraph 2 of the record, and he was not of the standard of a starting player for the men's national Iridonian football team and was only replacing the starting goalkeeper.
Yeah, Counsel, can I just check for the first point that he chose to play despite not feeling well? Well, I understand where you're coming from, that it's possible that he was not involved in match fixing because he played despite being sick in order to win the game. But I could also infer that it was because of the possibility that if let's say he was involved in match fixing, that despite being sick, he nevertheless wanted to go out to the field to control the score. So do you have anything that, supports your case over the alternative?
Mr. President, I know my time is up. May I request time to finish your complete?
Yes, please, go ahead.
The performance of a player, poor performance, cannot merely be considered to be match fixing. And this is what the past CAS panel has held. For example, in the 2017 CAS decision, Oleg Penkovsky versus LFF at paragraph 110 to 119, there were allegations, I quote, of the players who deliberately losing the ball, made deliberate errors, made passes to the opponents, and did not prevent opponents from coming close to their team's goal. And the panel held that this was insufficient evidence to find the appellant guilty of match fixing, because if poor performance could simply be the reason, then every single soccer player could bring forward a claim for match fixing based on poor performance. Unless there are no further questions, this concludes my submissions. Thank you.
Thank you. Ready? Mr. Arbitrator, the panel, may I know who is the president in this sitting?
That would be Mr. Liu.
Mr. Liu, thank you. So may I begin? Thank you. Good morning, Mr. Arbitrator, Mr. President. My name is Mark, and together with my co-counsel, Mr. Austin Seah, and we represent the respondent FIFA. I will address two issues in these 10 minutes. Issue A, whether Mr. Fortuna appeal is admissible, and issue B, whether his refusal to surrender his phone was lawful. And Mr. Austin will address the remaining issues. We respectfully reserve 1 minute for sub-rebuttal. On issue A, our submission is straightforward. The appeal is inadmissible for three independent reasons. First, the statement of appeal was not filed by the 23rd April deadline. Second, the reinstatement should not be granted because the request was not made promptly. And lastly, even if the statement was rescued, the appeal brief was late under Rule 51. We accept that the appellant's starting point under Article 50, subsection 1 of the FIFA statutes, the time runs from the receipt of the full grounds. And on these facts, the operative deadline for the statement of appeal was 23rd April. But the problem is simple. The CAS never received the email. There was no filing. If I may take the panel to record paragraph 29, page 5. The CS Court Office states that it never received the appeal email and had not registered the appeal even by the 28th April. Under CAS Code Rule 31, for electronic filing, a statement of appeal is valid upon the receipt of the CAS Court Office. This is exactly the point made in Hungarian Football Federation and FIFA in the 2022 case. An email filing must enter the recipient's sphere of control. Here, that never happened. And finally, according to record paragraph 31, page 5, we see it's telling that the appellant requested reinstatement. That request itself concedes because the filing was not on time. So to plain the record and the code, the statement of appeal is out of time and invalid. Now, the reinstatement
I'm
should...
sorry.
Yes.
Doesn't this go against the court's general pro-arbitration approach where whatever is said on the procedural rules can be subject to flexible discretion of the court?
Yes, Mr. Arbitrator, it does. But at the same time, it is important to note that the court, in order to make sure that the courts are using fully Mr. Arbitrator, the discretion is reinstatement itself. And with respect to the question itself, if we were to allow this, the legal certainty and equal treatment would be out of proportion, and we need to follow a set of framework to make sure that the court is following a specific framework and rules and regulations. Now, even if the panel considers reinstatement, CS is reluctant to grant it because the deadline exists to protect its equal treatment and legal certainty. That strict approach is confirmed under the Swiss law in the 2016 CS case of SFT claimant and FIFA at paragraph 42, which emphasizes the strict application of appeal deadline to preserve the equal treatment and legal security. Now, the CS panel accepted two cumulative conditions for reinstatement as reflected in the 2024 CS case of FCSB and Glatzeri, that the hindrance must not be of the party's fault and the party must seek reinstatement promptly. The FIFA does not contest that the first limb for present purposes. A cyber disruption may be outside of the appellant's control. We contest the second limb, which is there was no prompt action. And using the record, we would like to show that the lawyers chose to file on the last night at 11:45, according to para 27, page 5 of the record.
I'm sorry, why is that inherently problematic? Because the ability for lawyers or counsel to collect evidence is quite time sensitive, and shouldn't the court take into account that fact?
What?
And to follow up on that, I believe that we're talking about whether or not there was, correct me if I'm wrong, but we're talking about whether there's prompt action in uh, in sending out subsequent emails, right? Given that it is. So why does it matter when the email was sent out at first instance, given that we're trying to see if after given that we're trying to look at whether or not the actions after the deadline was prompt, if that makes sense.
So, Mr. Arbitrator, to answer these two questions, I would like to first mention that the screenshot of the WhatsApp image, which is on page 52 of the PDF, Exhibit 9, it clearly states that the message was sent at April 26, 2026, whereas the submission was made on 28 April 2026 for the appeal of reinstatement. So sorry, Mr. Arbitrator, sorry, Mr. President, could you repeat your question again?
Yes, so you said that you are debating on the second limb or whether we should reinstate, right? And it's on whether there was prompt action. But earlier you said that there is no prompt action because the email was sent on the 23rd at 11:45. But in looking at whether reinstatement should be given, are we supposed to look at, aren't we supposed to look at whether or not there was prompt action after the deadline to rectify this issue? And so if that's the case, then why does it matter that before the deadline they sent it at 11:45?
Mr. President, because even though it was sent at 11:45 on the last night, they only contacted the CAS court office on the 28th April, which was a Tuesday, according to paragraph 30 of the PDF. So there was a delay in even inquiring regarding whether the email had received or not. The court office had received the email. Thus, we are trying to imply that there was no promptness from their point of view.
Okay.
Mr. President, now moving on to issue B of refusal.
Sorry, before that, can you
Yes, Mr.
give
Arbitrator.
me examples of exceptional situations that will fit to such that it would allow this exception to apply?
Yes, Mr. Arbitrator. So I would like to refer to the case of Christina Iov, where the appellant relied on technical difficulties and Iov is directly against him. The CS rejected the attempts to shift responsibility for the email and security issues away from the filing parties. The risk of managing one's electronic traffic lies within the party's professional sphere. And also the 2023 CS case of B and FIFA, it was held that no fault impediment standard requires the utmost diligence and precautionary steps must be taken during the appeal. Where an issue arises, the counsel must act by substitution, delegation, or immediate measures. The same logic applies here. I understand, Mr. President, I understand that I'm running out of time. May I request for 2 more minutes of time extension? Thank you very much.
Yes, please go ahead.
So moving on to issue B now regarding the refusal to hand over the phone. Issue B is also very simple. Mr. Fortuna's refusal to surrender the phone was unlawful because he breached the duty to cooperate under Article 12 of the FIFA disciplinary committee, and he cannot rely on self-incrimination under Article 6 of the ECHR on these facts. Therefore, an adverse inference may be drawn and a fine is proportionate. Article 12, subsection 3 of the FDC requires a person subject to the court to help establish the facts provided and provide evidence requested. Mr. Fortuna is bound to this. And according to record, and the Article 14, subsection 1 of the FIFA statute requires members association to comply with FIFA regulations. Iridonia is a part of the FIFA, is a part of the FIFA association, according to paragraph 1, and Mr. Fortuna is under the Iridonian FIFA association structure. The duty is general but real, as confirmed by the 2022 Chilean Football Association and FIFA appeal decision. On the facts, the breach is clear. Mr. Fortuna immediately refused to surrender his phone. According to record, paragraph 20, page 4, and he maintained that refusal despite repeated request. This mirrors the principle in Jerome Valcke, where refusal to provide requested documentary evidence constituted a violation of the duty to cooperate. Now,
Sorry, I just have a question, and you can you can take your time to answer this. But because the appellant brought up the privilege against self-incrimination, so I was wondering if you could address on that point and why it should not apply in this case, or there's an overriding obligation on the appellant to have surrendered his phone. You can take your time in answering this. Don't worry about the time limit.
Yes, Mr. Arbitrator. Mr. President, thank you. So the opposing counsel mentioned Article 6, but we would like to assert that Article 6 does not excuse cooperation here, because the CAS has set the bar very high before a person who can refuse cooperation. In the 2017 case of Jerome Valcke at paragraph 266, it was said that the privilege might extend only when there is a clear and imminent danger that a sporting body is being used to circumvent rights before public authorities, typically requiring collaboration and information sharing with the prosecutors. The danger is absent here because the strongest fact is that Eridonian prosecutor refused to share evidence with FIFA and will only do so at the end of the criminal investigation. And this is also mentioned on the record at paragraph 50 to 16 on page 4. And this negates any claim that FIFA is acting as a proxy to the state. And if the appellant also relied on the case of Funke and France, and that case is also materially distinct because it involved state coercion in criminal proceedings, whereas FIFA has no search warrant power and enforces contractual regulatory duties within the sport. I hope that answers your question, Mr. President. Now, I would like to conclude my submission if there are no further questions and hand my time over to my co-counsel, Mr. Austin. Thank you.
Before I begin, members of the panel, can I confirm that I am audible and visible? Thank you. Good evening, members of the panel. As earlier introduced, my name is Austin Seah, and I'll be addressing the remaining 2 issues on appeal. Turning to the third issue, we submit that the anonymous witness statement and email constitute admissible evidence as it meets the requisite conditions for admission under Article 6 of the ECHR. This tribunal is seated in Switzerland, and as a result, the procedural validity of these proceedings are governed by Swiss law, in particular Articles 182 subsection 3 and Section 190 subsection 2 of the Swiss Private International Law Act. And CAS jurisprudence, such as the 2009 CAS decision of FK Pobere and UEFA, noted that this has to be interpreted in light of Article 6 with respect to the admission of anonymous evidence, and they laid out 3 criteria to be met. Firstly, there must be good reason for non-attendance. Secondly, the evidence must not be sole or decisive. And lastly, there are counterbalancing factors that safeguard the fair assessment of reliability in the absence of cross-examination. And turning to the first element, as noted in the 2019 case of Karim Karamuddin, this panel does not require concrete proof of threats or past violence, as correctly noted by Mr. Lai in his question to Mr. Brandon earlier. As in Karamuddin, the CAS had accepted anonymity because the allegations went beyond sporting misconduct and engaged serious criminal conduct exercised by individual.
Naturally, I would point you again to paragraph 188 of the case, which says that the failure to corroborate evidence or to show that there are extenuating circumstances which prove the validity of these threats would mean that it is unsubstantiated.
I understand, Mr. Lai, but in our case, as noted in Karamuddin itself, it's an issue of a possible threat. And in our case, it alleges sporting manipulation, alleged criminal networks, and substantial cryptocurrency transactions. And moreover, if I may turn the panel's attention to PDF page 32, paragraph 6. The alleged source of the pressure is the appellant's father, described as a person with friends in the criminal world. As in Karamuddin, this power imbalance, combined with the criminal allegations where the IPP had initiated criminal proceedings as noted by the appellant, materially increases the risk of intimidation, even though there are no actual threats.
And regards to the second element, the respondent does not rely on the anonymous witness statement in isolation. As CAS made it clear in the 2009 decision of FK Pobeda and UEFA, this decision is whether the witness evidence and email are corroborative rather than decisive, as earlier questioned by Mr. Lai. In regards to corroboration itself, if I may turn the panel to PDF page 33, paragraph 9. The anonymous witness describes a tense and stressed appellant on the night of 16 October 2025, specifically overhearing him telling his father to stop pressuring him. And this aligns with the Genius report, because the report noted that there was anomalous betting activity in Comeland's favor, which began 12 hours after kickoff, and this can be seen at the area Genius report titled Match Result / Asian Handicap. And this is noted at PDF page 15 at the first paragraph.
Okay.
And therefore, we submit that this timing aligns perfectly with the pressure described by the witness on the evening of the 16th, which directly addresses the corroboration issue. And turning to the third element, in Karamuddin, the CAS had accepted reliance on anonymous statements despite the absence of cross-examination because the statements were indirectly tested through procedural safeguards that preserve overall fairness. And on this note, we note that counsel for the appellant has alleged that in our case, there has been no similar safeguard such as the voice recorder that was provided. However, in Karamuddin, the CAS emphasized that internal consistency is a key mechanism that can be considered as an alternative when there are no such voice scrambling methods available to protect the witness in our case. And the panel assessed whether an anonymous witness were coherent, whether they acknowledged their own limitations, and whether they avoided exaggeration. And all of these three factors have been noted in our case. Because as turning to the witness statement, the witness recounts a specific contemporaneous observation, a stress phone call before the match, while expressly acknowledging the limits of what he could hear or know, as he did not state to claim what the appellant's father had stated. As in Karamuddin, the witness had similarly not speculated about any betting or criminal arrangements, but confines the account to what was personally observed. And this internal restraint is precisely the type of features that CAS treats as a reliability indicator. Unless I may be of further assistance on the third issue, I'll turn now to the last issue. Turning to the last issue, we submit that the appellant had violated Article 20 of the FDC. And before I begin, I would like to address the framework or the method that this panel has to take in addressing whether a violation has been made out. Because the 2009 CAS decision of FK Pobeda noted that match manipulation is rarely proven by a smoking gun. And therefore, the CAS must assess the evidence globally and reach a comfortable satisfaction from a converging set of circumstantial indicators, which is noted.
I can accept that, yes. But my issue is that the appellant has submitted that the inexperience of this player has to be taken into account. So naturally, the question is, I understand that there are many major mistakes made in a sporting sense by the appellant, but can it really be attributed to some sort of malicious intent rather than his incompetence and the fact that he was called up immediately and had no prior preparation time?
Certainly, Mr. Lai, and I will address the three claims that the appellant has made in this respect, which was that he was a substitute, that he was sick, and he was injured. Now, turning to the fact that he was a substitute, actually, this was not the first time he has been playing as a goalkeeper. If I may turn the panel's attention to PDF page 18, under the comment noted by the manager, which is the third Twitter post, he noted that he has been great all campaign and kept us in matches single-handedly. Therefore, the appellant's claim that Mr. Fortuna was only inserted in this match as a last minute is unfounded, because it is clear that throughout the entire season, the team has utilized Mr. Fortuna as a goalkeeper and shows that his prowess has kept them all the way to the finals. And this shows that the manager had also acknowledged Mr. Fortuna's impact on the game. And if I may turn the panel's attention to PDF page 11, the fourth paragraph from the background title. It was noted that he was expected to maintain his pace. So this means that he has been standing in for as a goalie for some time, giving the team a good track record in past matches. And turning to the second allegation that the appellant was sick, well, if he was truly sick, he would have sustained poor play throughout the entire tournament. And if I may turn the appellant's attention now to passages of interest at the 82-43 benchmark, which is at PDF page 16. Crucially, at the 82nd minute, if the appellant was truly sick, he would have suffered from not just sickness, but fatigue itself. And yet, he was able to save an extremely difficult goal, which was even considered by counsel for the appellant himself. And notably, the sickness...
Wait, sorry, but counsel, he didn't save it, right?
Yeah,
They scored, didn't they?
No, the effort was well saved by the Iridona goalkeeper Fortuna
Okay,
at the last
right.
juncture.
Okay.
And notably, the allegation that he was sick has no substantial proof on the facts. And now turning to the last assertion that the appellant was also injured, or that the teammates had also messed up on a report itself, which the counsel for the appellant has relied on severely. We have to understand that what we are ascertaining here are the actions of Mr. Fortuna himself and not the players on the field. And now it could be said that the poor actions of the teammates resulted in the betting anomalies during the match. However, if I may turn the panel's attention to page 14 under the title Conclusion, it's noted that the betting markets became abnormally confident in the comment when even before the appellant, let alone any of the players, stepped onto the pitch. Therefore, the actions of the teammates cannot be analysed individually. When seen together with the betting patterns, their actions definitely did not contribute to the anomalous betting patterns that occurred prior to the start of the match, resulting in the Genius report awarding a red grading, which shows anomalous betting that could be evidence of match manipulation. And now, noting that counsel for the appellant has also alleged that there is no conspiracy or no evidence of a conspiracy, I earlier noted that counsel for the appellant had the phone call with his father, which directly tied to the fact that there was an increase in betting activity. And notably, in the witness statement itself, the appellant had spoken to his father for a few minutes after the phone call. And at this juncture, considering that betting anomalies had taken place right after the phone call, it could be said that the appellant finally conceded to his father's demands and ultimately gave in, which resulted in the betting anomaly. I note that my time has elapsed, and unless I may be of further assistance on the last issue. Thank you, members of the panel. This concludes my submissions.
Sorry, before you continue your rebuttals, give us 2 minutes to confer.
Certainly, members of the panel. Thank you.
Thank you.
Okay, we are done deliberating. Hello?
Hello?
Yeah,
Okay.
Yeah, so I assume that everybody, including both sides, can hear me.
Oh, yes, we can.
Okay, so With accordance to how the proceedings are run, the judges have a few questions for you to consider in your rebuttals, and we will give you additional time to consider the implications of these questions. So there are five. The first is, are there any guidelines that this tribunal can refer to when understanding whether a cyber attack or a cyber issue is something that is exceptional, allowing for reinstatement? That's the first. The second is, specifically for the appellant, is there a very exceptional circumstance where surrendering the phone would lead to significant prejudice or rights being violated? Because it is my understanding that
Turn to Article 8.
it is my understanding that not surrendering your phone or voluntarily providing information for investigation can lead to significant negative inferences being drawn against you in the proceedings. The third is with regards to the notion of anonymity, what is the court's standard practice and view on whether people who have potential risks should be generally kept anonymous or generally brought to court? And is there any policy or substantive reason as to the approach that you are submitting on? That's the third. As for the fourth, with regards to the standard of proof applicable in this case, I understand that there's lots of circumstantial evidence being used by both sides to substantiate their case. So I would appreciate some submissions on the requisite standard of proof, if any, as relevant to your arguments. Number five, when ruling on human rights issues, which are related to employment and the right to be heard, how do we take into account the RSC versus Sarahing decision in 2024, which states that any issues heard by sport arbitration courts on human rights issues are never final and binding on the parties? And does this decision in any way change the way that we should be looking at this, not as a final appeal court, but as an interim or middle court? So I'll give you 5 minutes to think about your responses to these questions. And for both of the parties, please address me for 5 minutes. Both speakers can speak on the issue.
Okay. Should we mute it because we're going to start first?
I'm gonna go to the toilet real quick.
I will leave for a while. I'll come back with some water. Thank you. Do you guys need more time?
No, I think they're asking us if we need more time.
Yeah,
Yeah.
let me just
No problem.
just 1 minute. If we can just have 1 minute here, then I'll be ready. Yeah, I'm ready if you are.
Can I confirm that the panel is able to hear and see me clearly? Okay. And can I also confirm that we have 5 minutes to respond to these 5 questions?
Yes.
Members of the tribunal, with regard to the first question on determining the guidelines to refer to when determining exceptionality, there is no contention between both parties in that it is a two-limb test. Firstly, there must be no fault that is applicable to the applicant. And secondly, the applicant must have been prompt in seeking reinstatement. Now, I note that during opposing counsel submissions, Mr. Arbitrator had questioned what is the relevance of the 2349 timing given that promptness is sought after the occurrence of delay. This intuition is well founded in that promptness is only to be considered after the delay has occurred. Thus, in the present situation, whatever opposing counsel refers to as a delay is the 2-day time gap between being notified of the cyber attack and having submitted the request for reinstatement. However, in this particular case, when Mr. Arbitrator asks opposing counsel what is the threshold for the promptness requirement, opposing counsel refers to the Christina Iowa case, but does not go so as to answer the exact question on why they consider the 2-day gap to be insufficient to hit the threshold. And the reason for this logical lacuna in opposing counsel's submission is because the Christina Iowa case rejected the appeal for reinstatement not because of the promptness requirement, but rather due to the no-fault requirement. And in this case, and the case that the applicant cites, both cases state that the promptness requirement is one to be considered with regard to all the circumstances and context of the applicant. Now, in the present case, if a cyber attack has just occurred and they are notified of it on a non-working day, a Sunday, they have virtually taken 1 day in order to get all their systems back online, back together, before submitting the statement of appeal on Tuesday. Thus, we would argue that given the circumstances, this hits the promptness requirement. And with regard to the second question on whether not surrendering the phone is truly protected by Article 6, the threshold requirement for this is that there must be an imminent danger that is shown so as to invoke the right against self-incrimination. And opposing counsel in this regard states that the public prosecutor had denied any collaboration requests from the FIFA office. However, what is to be noted is that despite this, FIFA had indeed already sent evidence that is collected in this particular issue to the public prosecutor, and this is the anonymous email and the screenshot that was attached in the email. And what is to be noted is that this actually runs counter to the regulation that FIFA has in its own FIFA disciplinary code at Article 34, which states that whatever evidence that is disclosed within FIFA proceedings should be kept confidential. So members of the tribunal, if FIFA is willing to skirt its own regulations to disclose evidence that is collected against the appellant would be justified in conceiving imminent danger in order to avoid surrendering his phone. And with regard to the question on whether an adverse inference can be made, yes, an adverse inference can be made due to an omission to cooperate with investigations. However, in this particular scenario, it's not a situation where the appellant has refused to cooperate with the investigation, but rather he's just seeking to conserve his right against self-incrimination in a consequent criminal proceeding that he's concurrently facing. Moreover, even if an adverse inference is to be made, a finding of guilt cannot be solely made based on an adverse inference. Now, with regard to the question on anonymity, the principles that are guiding this would be equal treatment of parties and the right to be heard. Due to these two principles, there's a general bar against anonymity. Because if a witness remains anonymous, then the opposing party is rid of the opportunity to cross-examine. However, this particular exception exists if three elements are met. Firstly, there's good reason for anonymity. And secondly, whatever evidence that is submitted anonymously is not sole or decisive. And thirdly, there are counterbalancing measures to safeguard against the lack of cross-examination. Now, in our present case, I note that my time has elapsed. If I could request for an extra 2 minutes to sum up the rest of the questions. Now, with regard to the present case, the first two elements are not in contention. It's only the third element which is in contention, whether or not enough of the counterbalancing safeguards have been met. And we state that due to these measures that were presented in Keramuddin, such as an audio-visual protection being provided for cross-examination, and in the present case, this is not something that opposing counsel has allowed for, we would suggest that the requisite threshold that is shown in CAS jurisprudence has not been met. Thus, there are not sufficient counterbalancing safeguards to say that there is no need for cross-examination. My opposing counsel will answer the last two questions.
Members of the panel, to address the circumstantial, the standard of proof, in sports law, that is the mere comfortable satisfaction, which is more than a balance of probabilities, but less than the criminal beyond a reasonable doubt. However, it has been held by the panel that it falls on the higher side, right below a reasonable doubt. And briefly here, Exhibit 1, the panel's held that alone is insufficient, and the panel may infer based on the circumstantial evidence presented on its totality. We agree with this. However, Exhibit 2 and 3, the anonymous evidence, has still not yet been identified. And Exhibit 2 is specifically double hearsay. It is a witness who refused to be identified at paragraph 5, and he refused to testify against something that he heard on the phone from Appellant and his father, and we don't know exactly what they were talking about on this phone call. And so therefore we submit that even if the panel makes an inference, it should still consider the fact that the evidence is insufficient, and insufficient evidence cannot become sufficient simply because there is other evidence to go along together with it. And on the last human rights issue, I noted counsel, may I just have 30 seconds to answer your question? The fifth question here, I did, I think they're okay. So what was the submission?
Okay. Members of the panel, I would like to answer the final question. Apologies. With regard to the fact that human rights decisions are not final when they are decided upon by the CAS panel, this is indeed true because any decision that the CAS panel makes is subject to annulment by the Swiss Federal Tribunal by reason of the fact that this panel rests in Switzerland. However, this does not affect our proceedings today in any procedural manner, except substantively, whatever decision that the CAS panel makes today, the principles under which such decisions are made have to be aligned with the principles that the Swiss Federal Tribunal considers when they decide, in order to avoid annulment. And this is the main reason why the ECHR is relevant. We conclude our rebuttals, if there are no further questions.
Good evening, members of the panel. Am I audible? Members of the panel, I will address the first two issues, and my co-counsel will go on to address the last three issues. So we would start with the cyber attack itself. As we have mentioned earlier, that the lawyers chose to file the submission at 23:45 hours, which was the last night. And if you file 15 minutes before the deadline, before the midnight, diligence requires verifying receipt. Whereas we see here that they only contacted CAS on the 28th April, which was a Tuesday. A simple email or phone call to the CAS could have been made the next day, and it did not require any effort from them, just a phone call. Even if we consider that their systems were still had malicious viruses, or they were infected with other sorts of different issues, they could have just made a simple phone call to the court office itself. But they still did not do that, and they only contacted CS on the 28th April, which was a Tuesday. And using this flow of logic, I would like to also highlight that under the IBA guidelines of party representation, the representation procedural obligations are treated as obligations of the party, which means the party bears the consequences of its representatives' conduct. Now, on the last issue of policy and reasoning, I would like to highlight the case of SFT claimant and FIFA, where it was emphasized that it is a strict application of appeal of deadlines to preserve equal treatment and legal security. So even if the panel considers reinstatement, CS is reluctant to grant it because deadlines exist to protect equal treatment and legal certainty. And if the panel were to accept this, the equal treatment and legal certainty framework would just fall apart. Now I'd like to hand my time over to my co-counsel.
Thank you. Members of the panel, to address your third question on the policy for anonymity, this is something that counsel for the appellant has clearly left out when addressing the three limbs, because we have to also consider the wishes of the witness himself or herself, specifically in what capacity he or she wishes to provide evidence. Based on the uncontested fact, it is clear that the identity of the witness is within a mere team of 10 individuals, which is noted at PDF page 14, making identification simple by the applicant's father. Therefore, it is extremely plausible that in spite of all the safeguards imposed to ensure the witness's identity is protected during cross-examination, there's a possibility, however small, that Mr. Luck Fortuna has a way to undo the voice scrambler or has insider information as to where the witness is providing his testimony. And notably, if we do force this witness to testify, he may not have even issued his witness statement in the first place. And as match manipulation is an increasingly seen case in CAS panels, we do submit that allowing the witness to participate in the ways that they are willing to does ensure that match manipulation claims are found and quashed. And turning to the fourth question, we agree with counsel for the appellant that the threshold is comfortable satisfaction. However, as noted in the framework of FK Pobeda, corroboration of other evidence seen together forms the mosaic framework to establish a claim under Article 20. Therefore, counsel for the appellant, while he asserted that we should not be relying on Exhibit 2 and 3, the fact it directly corroborates with evidence from the Genius report, which has been noted by the report itself to be objective and relied upon in many previous cases, goes to show that they have conveniently forgotten or rejected the mosaic framework that must be used to establish if match manipulation has been taken place. And regards to the last question by this panel, we have no contention with counsel for the appellant's assertion that the CAS panel isn't the final arbitrator. And notably, in the case of Mutu and Peshtin, these decisions by the CAS has been appealed to the ECHR and ultimately overruled. And unless I may be of further assistance to the panel, this concludes my rebuttal. Thank you, members of the panel.
Can you stop the recording?